Hi. So in this video, I would like to discuss about state of mind. So state of mind is a problem which a lot of CLAT questions deal with, sometimes directly, sometimes indirectly. For direct questions, we'll come to that later during this video. Indirect questions, any questions on tort law, contract law, or criminal law will always involve some element of state of mind, which is why a clear idea of a state of mind is very important for CLAT. So let's quickly move on. So the first thing we want to know is the difference between motive and state of mind. So the motive answers the question, why did someone do something, right? It answers the question, what was the reason behind him doing something. So if I kill someone, motive will be, why did I want to kill him? Something like, oh, he I don't know, he slapped me and that made me angry, or he insulted me or that made me angry. Those are all motives, right? So my motive was anger, revenge, right? But state of mind answers the question, what did he do, right? And what did he want? What was the outcome? And did he get what he wanted, right? So it's slightly counterintuitive in the sense that state of mind does not actually talk about what's going on in his mind, but it's an assessment of whether he was consciously doing that action and whether he consciously intended that outcome. Let's look at the next slide and get a little clearer. So there are three distinct states of mind. These are all fluid, like uh, these aren't concrete compartments, these are kind of fluid. So everything will either fall in this domain, or fall in this domain, or in this domain. uh, a little bit of background reading would help you identify these distinctions, but even if you do reading after this, it should help you understand why I'm saying it's fluid and not concrete, right? So voluntary action mainly deals with the question that did he do something, in the sense, was his decision voluntary? So if, say, I am walking on say there is this huge plot of land and I'm walking, right? And most of it is public property, but at some point, and there is no boundary, and I cross into someone's private property without realizing that I have finished the public property and I'm now in private property. So am I still guilty of trespass? Yes, you are, right? Because voluntary action only cares about did he do uh so here you have to just, did he do it consciously? Actually, yes, that's the best way to go about it. So did he do it consciously, in the sense that, did you voluntarily walk on your own 2 feet to go into someone's property? Then you are liable for trespass, right? No one cares that you didn't know that it was someone else's property and that you didn't really want to trespass, but as long as you voluntarily walked into someone's property, that's trespass. That's voluntary action. Same thing applies in nuisance. Say you are playing loud music, but you don't even realize that the music is loud, but it interferes with your neighbor's peace, and so you can be held liable for nuisance, right? Even if you did not want to disturb his peace. So that's irrelevant. So all you have to see is whether you consciously were doing that action. So in case I push you onto the field, then you will not be liable for trespass because you did not voluntarily go onto someone's private property. So now knowledge. So knowledge mainly answers the question, did he know that this could happen? So for negligence, you would want to see that someone put a potted plant on a veranda, right? And now that plant, and it was not tied down, so that plant fell and hit someone on the road. So now the question is, so his voluntary action was putting that plant on the veranda. So he's not liable for his voluntary action, right? So what, did he do it consciously? He put the pot on the veranda and the pot fell by itself. So there was nothing he did. So what, did he know it could happen? I mean, it's general knowledge, right? It's general knowledge that you cannot leave a plant lying on the veranda because without it being tied. Why? Because you know that it can actually fall, because you know that it can actually fall down, and you also know that falling objects can hit someone on the road. So that was foreseeable. That person that a person will get injured by you leaving that potted plant on the veranda was foreseeable. So did you know that it could happen? Yes, you knew that it could happen, right? And so you are liable. So it's slightly stricter than voluntary action, in the sense that here the voluntary action was just putting the pot on the veranda, so you didn't do anything wrong per se, but by using knowledge we could say that you could have seen that happening, you could have seen that it could happen, and hence you're liable for the consequences, right? Same thing with rash driving, right? So if you're drunk driving, you have that special knowledge that you are drunk and you're drunk enough and you should not be driving, or you are incapable of driving at that moment, and it's foreseeable that if you drive you are going to end up hitting someone, right? But you still go ahead and drive. So then are you not liable? Yes, you are liable because you knew this could happen, right? But here the liability is slightly higher because you best knew, like the special knowledge is unique, so you knew very well that you are incapable of driving and you still went ahead and drove. So you will be liable. So that's section 304A of the Indian Penal Code, right? It talks about this special knowledge, right? Now let's talk about intention. So in intention, both the act and the outcome, right, both the act and the outcome are chosen by you, in the sense here only the act, you only intended for that, you only did some act. Here you were aware of the outcome, right? So you are, even if your act is by itself not a violation, we are saying that since you knew this could happen from your act, we are holding you responsible. Here what is happening is you did something and you knew this could happen and you wanted that to happen, which is why you did something. For instance, say you were driving the car, you see an old enemy and you decide to just increase your speed and hit him. So in these both cases what happened is, like say in both cases the victim dies. In this case when you're drunk driving, and in this case when you actually go ahead and hit someone. So but what the difference is, here you knew it could happen, here you wanted it to happen, right? Here you may not want it to happen, so here you are not wanting it to happen. In this case you're not wanting it to happen, but you knew it was a possibility or a probability. Here you actually wanted it to happen, you wanted to hit that person or by your car. Here maybe you thought you would not hit him, but you were so you I mean, maybe there was a 90% chance you would hit him, but you never really wanted to hit someone, right? You just wanted to drive the car, and hitting him was ancillary to you driving the car. Here, you drove the car on him. You wanted that car to hit him, right? So your action was actually driving that car, and then the outcome which you wanted was hitting him. So both the things which happened was what you wanted. Here, your action was wanted but your outcome was not wanted. You knew that it's a possibility, so you're holding it liable, right? But here you wanted that action also, that outcome also, that result to happen from your action also. So this is intention, and generally intentional acts have the highest liability. Knowledge has relatively lower, and voluntary has typically lowest liability. All right, but again there are miscellaneous sections which just assume intention. uh, some examples are like section on possession of illegal drugs. So if you hold beyond a certain quantity, you are liable for intention to distribute. You are charged as a distributor, right? But that is just law creating special state of mind. That may actually not be a state of mind. So now let's come to this next portion, which is very important. It's that evidence, right? So evidence of state of mind, why is that necessary? Because I don't know what's going on in your mind and you don't know what's going on in my mind. So how would you know that I voluntarily did something, or I want intentionally did something, or that I had that knowledge, that special knowledge, that general knowledge? How would you know that? Okay, general knowledge is objective and foreseeability is also objective, in the sense we apply reasonable standard. But how would you know about special knowledge, right? How would you know about whether it was voluntary or it was intentional? How do you distinguish all this? You can't. So what courts rely on is, one is express evidence. Say in confession, if someone confesses that yes, I wanted to pull that trigger and kill him, so yes, I am responsible, right? And say someone just says, oh, I was just shooting in the air and then the bullet landed on him, then he's not responsible for, say, murder, right? So he's not responsible for murder. But that confession, that's by confession. He confesses he was shooting in the air. That explains his state of mind, which is he did not want to hurt someone, but it could have been foreseeable that the bullet will fall down and hit someone. So he may be liable for knowledge, but not for intention. So that's one example of how you find out someone's state of mind, right? So how do you find out someone's state of mind? First is express evidence, and second is so in express evidence you also have questions in CLAT which tell you that. So for instance, they'll give you clues like dishonestly, using words like dishonestly, right, or fraudulently, or intentionally. All these words they use, or knowingly, right? So these words which they use often give us an express evidence about someone's state of mind. Now if they're not using that words, and typically what happens in real life is that you look into the case, you look what happened into the case, and then you decide what that person's state of mind is, right? So you basically assume that is what was going on into that person's head based on his actions, right? So here you use actions to determine state of mind, right? So this is very subjective. Now you can understand why this is very subjective, because one action, like, because every, so the determination will be different for different people, right? So if some actions uh someone interprets one way, I may interpret it another way, right? So for instance, I see you running on the road. So someone may say, oh, you are running after a crime, but I may assume that you are running after say you run for fitness. I mean, this is a crude example, but you get the gist of it, that everyone is making a guess about your state of mind. So your, so everyone will make different guesses, right? So this is subjective, and sometimes CLAT questions give these also, but these are typically poor questions because it's, unless it's very obvious, right? So these are poor questions because it's very subjective. Again, the person frame, you might not think exactly like the person framing the question, so it's very difficult to expect you to come up with an answer, right? So this is another issue that people have. They are not able to differentiate between the state of mind and how you determine state, how you guess someone's state of mind, right? So how would you know someone's state of mind? This is a better title. How would you, so either someone will tell you, right, or you can look at his action, right, or you can look at his action and then determine. So here again, now this is one idea of where you get this brief insight into how law has two aspects to it. One is what is written in the law. So in the law this is mentioned, right? Voluntary action, knowledge, intention. And there's a second aspect in what you can prove, right? So here the proof is entirely based on actions, right? So it's subjective. So that is why we say the application of law is as subjective as it is objective, right? This is just a quick fact I wanted to give you. Now let's just quickly dive into CLAT questions. Hopefully it will clear out some of the doubts, lingering doubts you may have after, despite the slides. So let's look at CLAT 2016 questions, right? So let's look at the first question. Here is one who dishonestly misappropriates or converts. I'll increase the size. Right, hopefully this is visible. So one who dishonestly misappropriates or converts to his own use or sells any movable property belonging to another is guilty of the offense of misappropriation. Okay, this is the principle, right? So now there is fact. right? So fact A takes property belonging to Z out of Z's possession in good faith, believing when he takes it that the property belongs to himself, right? Subsequently, A, on discovering his mistake without disclosing the actual facts, dishonestly sells the property to a stranger. Okay, now let's see here. It expressly says that A did it in good faith, right? That there was no dishonesty when he took the property out of Z's possession, right? So the dishonesty came later when he was selling. And here again, it's expressly mentioned that he was dishonest, right? So this gives us the idea here that he intentionally sold the property dishonestly. And here it says who dishonestly misappropriates. So dishonesty is a state of mind, right? So but it's expressly given in the question that he had that dishonest state of mind. We don't have to look at his actions to determine anything. It's expressly given in the question that he has a dishonest state of mind. So now let's look at the answer, right? He says one who dishonestly misappropriates or sells one's movable property is who dishonestly misappropriates or sells. So if he's selling someone's movable property dishonestly, then he's also guilty of misappropriation. So here the question is telling us that A actually dishonestly sells the property. So A is definitely guilty of misappropriation, right? So this is going to be the answer, right? See, I don't think there's any way to mark it. Let me just bold it, right? So this is the answer. We can just quickly look at the other options just to clarify. So the first option talks about theft, but the theft portion is not mentioned anywhere in the principle. So we can, I mean, it's unlikely that this is the answer because nowhere in the principle does it talk about theft, right? So we wouldn't know what would qualify as theft. Second, he's not guilty because when he took the property, he believed in good faith that it belonged to him. Okay, so up till this point, right, when he just took the property, A may not be guilty. But later we know that he sold the property dishonestly. So then A is guilty. So this is not the correct option, right? And fourth, A is not guilty as the property can be recovered from the stranger. Again, the principle never talks about recovery of property. So this is also unlikely to be the answer. So we can confidently say that our answer is the correct answer. Now, moving on to the next question. So, killing is not murder if the offender, whilst deprived of the power of self control by intense and sudden provocation, causes the death of the person who gave the provocation. Okay, now look at this question. So, there are a couple of components in this question. So, here there has to be an intense and sudden provocation, and there has to be the death of the person who caused the provocation, right? So these two are important elements. So now let's look at a man found his girlfriend sleeping in her own bedroom with another man named B. So this is an adultery question. I mean, not technically adultery because adultery requires marriage, but you get the idea. It's a cheating question, not cheating as per IPC, but cheating as per relationships. Anyway, moving on. So A did not do anything but went to his house, picked a gun and cartridges, returned to his girlfriend's bedroom with a loaded gun but found the place empty. Okay. After 15 days, he saw the girlfriend dining in a restaurant. Without waiting for even a second, he fired 5 bullets at his girlfriend who died on spot. Okay, so what are the elements that we need here? We need a grave and sudden. First of all, we need the death of a person who gave the provocation, right? And we need an intense and sudden provocation. So obviously, there's a death of a person who gave the provocation. What was the provocation? Who died? The girlfriend died. So that part is satisfied. Now, whether there's an intense and sudden provocation, and whether there's a loss deprived of the power of self control, right? This is also important. So whether he was deprived of the power of self-control. Now here you're talking about a situation where a person is not thinking straight, right? Where a person, I mean, not technically adultery because adultery requires marriage, but you get the idea. It's a cheating question, not cheating as per IPC, but cheating as per relationships. Anyway, moving on. So A did not do anything but went to his house, picked a gun and cartridges, returned to his girlfriend's bedroom with a loaded gun but found the place empty. Okay. After 15 days, he saw the girlfriend dining in a restaurant. Without waiting for even a second, he fired 5 bullets at his girlfriend who died on spot. is not, he just gets so overwhelmed by the provocation that he loses his self control and he kills someone. So this is a state of mind, right? This is a state of mind, that loss of self control. Now we, the facts do not expressly say anything, so we have to assume, like infer from his actions. So now look at his actions. So the man first found them in bed, right? And then he didn't do anything, right? And that was the sudden and intense provocation, that he found his girlfriend sleeping with another man named B, and that was a sudden and intense provocation, but he did not do anything then. He went back to his house and picked up a gun and cartridges, right? He did not directly attack A, B or his girlfriend when he found them. In fact, he went back to his house, picked up guns and cartridges and returned. And not only that, when he, after he found it empty, then 15 days later he saw his girlfriend dining in a restaurant and killed her. At that time, was there any provocation? No. Right? Was it sudden? No. Right? So you understand that this was not a case of grave and sudden provocation, because this man actually had the time to go back to his house, get guns, and even then, after not finding the place empty, he had 15 days to cool down, think about it. And then after seeing his girlfriend again, without any provocation in the dining, it does not talk about her provoking him in any manner, right? And he still goes ahead and kills her, right? So now the answer would be A is guilty of murder, right? So this should be the answer, right? Because you have assumed his state of mind. His state of mind was not that of loss of self control, and we have assumed this from the fact that he went back to his house, picked up guns and cartridges, and he found it empty, right? So he had the patience to go back to his house and pick up guns and cartridges. Then he had the patience to wait for 15 days, and after that, his girlfriend did not really do anything. He was carrying his gun around apparently for 15 days, and then he shot her in the restaurant. So there was no sudden provocation then, right? And there was no provocation also technically, right? Because his girlfriend did not really do anything. So this would be the answer. Now let's look at the options. A could have killed B instead of his girlfriend. So here it talks about the person who gave the provocation. So both B and his girlfriend gave the provocation. So this option cannot be justified, right? Yeah, so this option is also incorrect, right? Because if at the restaurant he could not have killed either of them, right? Because there was no grave or sudden provocation at the restaurant, right? So he could not have killed either of them, and that was not the first time he caught them together. The first time he caught them together was in her bedroom, right? So in the restaurant, it was not. It is not as intense or sudden provocation, right? So this option is also not likely to be correct, right? So now let's look at this. A killed his girlfriend under grave or sudden provocation, and the third option is A did not kill his girlfriend under grave or intense and sudden provocation. Okay, so it's possible for you to think that it is under intense or sudden provocation, but reasonably thinking, it's unlikely that a lot uh, that people would consider this intense and sudden provocation. So intense and sudden provocation is supposed to be a very emotional event, right? And it has to be, there has to be a proper provocation. It cannot be anything whimsical. And a proper provocation in the sense means like an emotionally taxing event, and an event of seeing your girlfriend in a restaurant 15 days after she cheated on you is emotionally taxing, but it's not taxing enough to be considered as intense and sudden provocation. Okay, but that's totally my opinion, and but in my opinion, this is gonna be the right answer, right? And you are free to have this opinion, but I don't think that's a reasonable stance to take given the current fact. But here you get where the element of subjectivity comes in, because we are using his actions to determine his state of mind. There is always scope for subjectivity. So it's impossible for me to say objectively that I'm correct and you are wrong if you pick option 4 instead of option 3. Right. Now let's look at the let's do this question last, right? So, nothing is an offense which is done by accident or misfortune and without any criminal intention or knowledge in doing of a lawful act in a lawful manner by a lawful means and with proper care and precaution. Okay, let's look at the elements, right? So, which is done by accident or misfortune, right? And it says and without any criminal intention or knowledge in doing of a lawful act in a lawful manner by lawful means and with proper care and caution, right? Let's look at the facts now. A takes up a gun not knowing whether it's loaded or not, points it playfully at B and pulls the trigger. Consequently, B falls dead. Now see, we get an idea about his state of mind from this term playfully, right? So we may jump to the conclusion that it's accidental, right? But this is, you have to look at other elements of the principle also. So it says it not only has to be accidental, but it also has to be done without any knowledge, right? And with proper care and precaution. So here A did not check whether the gun was loaded or not, right? A did not check whether the gun was loaded or not, right? And A A had that knowledge that if the gun was loaded, B could end up dead, and he still went ahead and playfully pulled the trigger, right? So ideally, A should be held liable, maybe not for murder, but for some other crime, right? So now let's look at the options. B's death is not accidental as there was want of proper care and caution on A's part, right? So this, in my opinion, will be the answer. But let's just check the other options. B's death is accidental as A had no intention to kill B. B's death is accidental as, okay, so let's deal with this option. As A had no intention to kill B. But you see, intention is just one element. It also has to have a lawful act, lawful manner, lawful means, and with proper care and precaution. Merely because A did not have any intention does not automatically make it accidental. So here when you say accident or misfortune, it's a legal term. It's not a dictionary term. So you cannot interpret it as you interpret it in daily life, right? So this option is incorrect. A's death is accidental as A was just pointing the gun playfully at B. Now you see there's actually not much of a difference between these two options, right? I mean, if A had no intention and A was just playfully pointing also means A had no intention. So these both these options actually are incorrect. B's death is accidental as A did not have knowledge that the gun was loaded. Okay, we first of all, again, knowledge is just one part of it, right? So by knowledge here we mean that he should have the general knowledge, he should have that special knowledge that the gun was loaded or not loaded, and it should be foreseeable that if the gun is loaded and he shoots, playfully pulls the trigger or whatever, someone is going to die, right? So let's assume that he did not have that knowledge, right? It's not given anywhere, but by this word playfully we can assume, see, it's a poorly framed question, so by the word playfully we are assuming that he did not have that knowledge, but he still lacked proper care and precaution, right? So before playing with a gun, the least you can do is check if that gun is loaded or not. That's a very reasonable, demand, right? So yes, so I mean, so all these elements have to be fulfilled, like accident or misfortune. For it to be declared accident or misfortune, first there should not be any criminal intention or knowledge that your action might lead to those consequences. Second, it should be a lawful act in a lawful manner by lawful means. And third, there should be proper care and precaution, which was clearly missing from this. So for me, the most appropriate option is going to be proper option 1. Okay, so that's it. At the end of this video, you can contact us on our Facebook page, which is PostArt Law, if you have more topics you'd like us to make videos on. or if you just need some help with CLAT. Yeah, that's it. Thank you.